probation October 29th of 2018 for aggravated robbery, a first-degree felony. Again, that was a 10-year deferred probation. Is that correct? Each of these motions allege that you probation. Count one in each motion alleges that you committed the offense of burglary of a building March 22nd of 2025 in Jefferson County, Texas. And is that true or not true?
Not true.
Count two in each case alleges that you provided a urine sample March 18th of 2025 that tested positive for methamphetamines and marijuana. And is that true or not true? True or not true?
True.
Count three in each of the cases alleges that you were at a location other than your residence at 11:15 p.m. March 22nd of 2025. And is that true or not true? I'm sorry?
Not true.
Okay. Count four in each case alleges that you are behind in your court-assessed fees, and it's just a little bit in each case, $29 in one and $37 in the other. Is that true or not true?
Yes, true.
Did you enter your pleas of true in each of the cases to counts 2 and 4 freely and voluntarily? The counts that you pled true to, 2 and 4, did you do that voluntarily?
Yes, ma'am.
And did you plead true to those counts because those two are actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 2 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your cases for a hearing. The state on that date, if they want, can put on evidence with regard to any other allegations, and anything that you think is important for me to know, get that information to Mr. Kimler. He will present it to me on your behalf when we come back. I'll also get probation to do an updated report as well. All right, back with the bailiff.
Your Honor, if I may, this is deferred. I think the court has set bonds in the cases. They're relatively high. I believe they're.
Do you want to file a motion for, if I've already had a hearing with another attorney, I don't, unless there's some change of circumstances, I don't, we're not going to do that today for sure. But I would need some change of circumstance if I've already had a hearing.
When the reset is, can we get a speedy reset? Or how long?
You're going to get the same reset on a motion that we get so that everybody can get prepared and so that that updated report can get taken care of.
I'll be out to see you.
Good morning, sir. You are Brandon Chillo? And in cause numbers, or in cause number, I'm sorry. Is there two cases? Yeah. 19-32403 and 19-32404. Mr. Simon, good grief. Sorry, Miss Simon. Mr. Chillo is on probation in each of those cases, was here previously and entered pleas of true to motion to revoke probation to counts 1, 2, 3, 5, and 7. I've received an updated report, and has everyone had an opportunity to review that report?
Yes.
Any additions or corrections to that report?
Nothing finished.
Judge, the only thing I have is, in speaking with Mr. Hoffbauer last week, it was not his position, I don't believe, to put on any additional evidence because of the fact that Mr. Chillo pled true to count 1. The others just kind of actually patterned that, and based on Ms. Simon's recommendation, continuing him on probation with JCDI. We don't have evidence of that. If the court needs it, we can get it. But
No, are y'all in agreement?
This is one of those courtroom moments where everything hangs in the balance. Two defendants, same judge, similar charges, but completely different outcomes. And the reason why, that's where it gets interesting. Today's case centers around probation, specifically deferred probation, which is essentially a second chance granted by the court. Stay clean, follow the rules, and you walk away without a conviction. Mess up, that deal disappears instantly. Now here's the twist both. Individuals in this courtroom are accused of violating that probation. We're talking drug use, curfew violations, unpaid fees, and even a brand new criminal allegation. The judge isn't just deciding guilt. Here she's deciding whether these individuals deserve another shot at freedom, or if it's time to send them straight to prison. Watch closely, because what unfolds isn't just about the lit, about accountability, choices, and how thin the line is between mercy and consequences. One defendant denies the most serious allegation but admits to others. The other already admitted to multiple violations. So the real question is how much leniency is too much, and who truly deserves it. This is a critical moment right here. The judge lays out the most serious allegation, burglary, and the defendant immediately denies it. That's significant because burglary isn't just a probation violation, it's a brand new felony offense. If proven true, that alone could completely derail any chance of staying on probation. But notice what's happening. While the defendant denies the biggest accusation, she's about to face questions about smaller, yet still serious violations: drug use and non-compliance. And in probation hearings, you don't need to prove every allegation. Just one confirmed violation can be enough to revoke probation entirely. So, here's the question for you. Does denying the biggest charge actually help her case, or do the smaller admitted violations already seal her fate? This right here is a subtle but powerful move by the judge. She's already found enough evidence to revoke probation, meaning legally. She could send the defendant to prison right now, but instead, she pauses. She resets the case. Why? Because this is the court exercising discretion. The judge is essentially saying, I have the authority to punish you today, but I'm choosing to take a closer look. That gives the defense one more opportunity to present mitigating factors, things like personal circumstances, rehabilitation efforts, or errors in the allegations. But don't mistake this for leniency. This is more like a warning shot. The judge is holding the line, giving just enough space for redemption, but making it clear that the outcome could swing hard in the next hearing. Would you have made the same call here? Immediate consequences or one last chance?
With that recommendation, Ms. Muffino? And Ms. Simon, that's still your recommendation? You believe that? It looks like, for the most part, Mr. Chillo, you've been doing everything you're supposed to, especially on the type of probation you're on, which is great, and that gives me less concern. But it looks like there have been some issues specifically with some drug usage that you need some help for, and probation is willing to give you that help and keep you on probation. I want to make sure you understand, if I go along with this today and continue you on probation, and if you violate again in any way, it is probably not going to go as well as it's going to today. Do you understand?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, 3, 5, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that.
And there it is, the turning point. The judge isn't ignoring the violations. She's choosing correction over punishment. But make no mistake, one more slip, this entire mercy disappears instantly.
I'm going to continue you on probation in each of your cases in order that, as a condition of that probation, you enter and successfully complete the JCDI program. You will be on the high-medium caseload, so you're going to be going to probation more often. You're going to be going to JCDI. If you test positive, if you continue to violate in any way, you're going to be back in here, and again, we're not going to have such a nice conversation. Do you understand? Yes, what you're on probation for is extremely serious. I appreciate that you're doing that part of your probation